I got her a great offer, a great settlement offer. She didn't even thank me. She refused it outright until I prepared her for trial. Come join me for a moment as I share with you what it was that I discussed with her during her trial preparation that made her change her mind. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney practicing law in the state of New York. So now this was a medical malpractice case, and towards the end of the case, as we're getting closer and closer to trial, I entered into negotiations with the defense attorney. And now the defense attorney finally came back and made a significant offer. I thought it was a terrific offer. And now I go to my client to discuss that offer with her, which I am obligated to do. And now I'm also obligated to give her my opinion about whether or not she should accept the offer or reject the offer. Ultimately, it's her decision. This is her case. So she has the final say. And you know what she said? She said, absolutely not. I will not accept that offer. That's insufficient for me to go ahead and settle this case. Fine, no problem. So now, in the days and weeks leading up to trial, I had her come into the office. And the whole purpose of that is to prepare her for what would happen at trial. Now, you should know that trial preparation is to try and simulate what it's going to be like at trial. So now I'm going to have her sit in the conference room. I'm now going to be asking her questions as if we are at trial. And when I question her, it's known as a direct examination. And I will be asking her open-ended questions that gives her the opportunity to go ahead and explain. Tell us what happened next. What did you do next? What happened then? Explain to us what you did. What did the doctor say? What injuries did you suffer as a result of whatever happened? And now she can go ahead and explain. And so we go through this process, and it's designed to make them feel more comfortable, to make the witness feel more comfortable, because now when we get to trial, I'll be asking them very similar questions, if not the same questions. But in addition to asking them the open-ended questions, my questions, I also have to prepare my witness for cross-examination. Every attorney does this, whether it's for the plaintiff, the injured victim, or for the defense. They always have to prepare their witnesses. Now, preparing witnesses doesn't mean we tell the witness what to say. Instead, we give them an idea of the type of questions that they can expect to be asked by the opposing attorney. We give them ideas about what to wear. We give them ideas about how important it is to be honest and truthful and to look at the jury when they answer their questions. So all of those things are critical in preparing a witness for trial. Now, during the course of my cross-examination, during the preparation session, my client started to get nervous. She started to get anxious. She started to get very worried. Why? Because she was having difficulty answering these basic questions. Now, I was asking her pointed questions, and I was showing her contradictions between what she has said during her pretrial testimony and answers that she was giving to me in my office. And I told her, I said, if the defense attorney asks these questions, he's going to point out and highlight these inconsistencies. And you know what else? At the end of the case, at the end of the trial, during closing arguments, he will turn to the jury and he will show and highlight every one of these inconsistencies. And then he's also going to ask the judge for a legal instruction to give to the jury. And you know what he's going to say? He's going to ask the judge for a special instruction known as falsus in uno. That's a fancy Latin phrase which basically says, hey, jury, if you find that a witness has lied about one thing, you have the right to disregard all of their testimony because they've lied about one small little thing. So that is a really important factor. And now, during the course of my pretrial preparation, I was able to show to my client, who was refusing to do anything to settle this case, that not only did she have one inconsistency, but she had 2 and 3 and 4 and 5. 5 inconsistencies that she really couldn't explain very well about why her testimony was different during her pretrial question and answer session compared to the questions that I was asking her now in my conference room. And because of that, because of putting her through the stages of what was likely to happen when we got to trial, she finally turns to me and says, you know what? I don't want to go through with this. I don't want him to make me out as a liar. I want to settle this case. And now, what do you think we did? I was able to settle this case, but only after I prepared her for going to trial. So why do I share this quick story with you? I share it with you just to give you an insight and an understanding into what goes on in these medical malpractice cases, these accident cases, and these wrongful death cases here in New York. I realize you're watching this video because you likely have questions or concerns about your own particular matter. Well, if your matter did happen here in New York and you're thinking about bringing a lawsuit, but you have questions that need answers first, what I invite you to do is pick up the phone and call me. I can answer your legal questions. This is something I do every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.